Great to see you all here. Thanks for being here. I'm Katrina Fenlon. I'm an assistant professor here at the iSchool at the University of Maryland, and I'll be introducing our speaker today. But first, let me introduce the Center for Archival Futures, or CAFE as we call it. This is a relatively new center here at the UMD iSchool. It started up in January of this year. We're a group of interdisciplinary researchers from the iSchool and beyond, whose work intersects at archives and digital curation, but very broadly conceived. So we're interested in the systems, processes, and institutions that care for and enable the use of digital objects and data over time. The various projects that fall under CAFE's umbrella take a wide range of human-centered approaches to understanding topics including data in communities, knowledge ecosystems, life cycles of data. And this speaker series is our flagship event. Normally held on the first Wednesday of each month during the semester, we host speakers who are at the cutting edge of archives and digital curation research and practice in a wide variety of settings. And you can find recordings of our previous guest speakers and information about our upcoming talks at the CAFE events page, which I can share in a moment. Including another virtual talk that's later today at 6:30 on Filipino lives in the DMV. But today's event is off cycle, and it's particularly exciting because it features one of our own. Jason Barron came to the iSchool in 2020 as professor of the practice after a 40-year legal career that included being the first appointed director of litigation at the National Archives and Records Administration. And prior to that, serving as a trial lawyer and senior counsel at the Justice Department. During the course of his time in government, he was involved in some of the largest and most complex cases involving White House electronic records and served as lead counsel on a number of FOIA lawsuits. Most recently, he's also collaborated with other iSchool colleagues, including Professor Doug Ord, on AI-related research aimed at improving how FOIA requests are handled. His talk today is entitled Secrets of the Freedom of Information Act, Everything You Need to Know About the FOIA Process, including Where to Find the Roswell Documents. Jason, welcome to the CAFE Speaker Series, and please take it away.
Hey, thanks. Thanks so much, Katrina. It's a pleasure to be here, pleasure to be at the iSchool. I know there are a lot of FOIA gurus out in the audience here. And so I welcome all of you, and I welcome the students that are part, hopefully, of this talk, or we'll see it in its recorded form. Let me share my screen and go from there. Okay, so my aim for this talk is to do a bunch of things. One is that I was invited by the CAFE faculty to give a talk to grad students and students at UMaryland who haven't necessarily encountered FOIA, and trying to make a FOIA process less intimidating if they were going to file a request as part of any research they do or just of their interest. I want to share some observations I have on history and importance of FOIA, especially in the digital age, and I also want to share some frustrations I've had about becoming a FOIA requester. And now I have multiple dozens of FOIA requests that I've been filing in the last year. I wish to highlight some recent research that I've been involved in applying AI methods to one particular FOIA problem and talk about that at some length, and then I will hope that you're going to stick around. So I promised to reveal about Roswell, but just so that you would hear everything else that I have to say today. So FOIA is actually, the Freedom of Information world is actually 255 years old, 200 years before the FOIA was enacted in the US. Sweden had a kind of freedom of information law, and I put a link up, and you all can take a look at that. So we, about 200 years later, we enacted something. Along the way, the idea of the fact that government records were important was noted by a founding father, James Madison, This is a well-known phrase in the FOIA community. A popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy. I think those are words that are applicable even up to the present day, given recent events. And so on to LBJ signing. So Lyndon Johnson signed the original FOIA in 1966. He did so from his ranch, not as a signing ceremony. He basically didn't feel comfortable putting it out in the world in the usual way. He made some, certainly made some statements to the effect that, he's always believed in freedom of information, but he couched it in a certain way. He basically said, look, there are instances where documents should not be made available, such as military secrets. And that has remained true throughout the history of FOIA, where government is being doing what it needs to do to protect its interests under FOIA exemptions. We'll talk a little bit about that. The FOIA was strengthened after President Nixon resigned in 1974. There's a set of reforms, Privacy Act, Government in the Sunshine Act, all followed from Watergate, but the FOIA was enhanced. I must say that President Ford objected and he vetoed the FOIA, and then the veto was overridden. He did so on the advice of various individuals who have become even more famous over time. So his staff members, Don Rumsfeld, Dick Cheney, and at the Office of Legal Counsel, Antonin Scalia. So let me go here. So the next development in sort of FOIA legislation was the EFOI of 1996, and requesters were given the right to ask for agency records in electronic formats. The reality, as I found it to be, is that agencies take that mandate as a mandate to give out documents in PDF, not in machine readable formats that are easier to manipulate and to search against. And so some agencies are ahead of the curve on it, but you're not going to find FOIA documents in XML or as the usual case, something that I think recommendations should go to for future amendments in line with open government generally. So there have been a couple of other amendments to the FOIA in the last 15 or so years, more or less. There's an Open Government Act of 2007. There are a bunch of procedural reforms about attorneys' fees being able to be recovered, and the Office of Government Information Services. And I'll say something else about them later on, but it's an important office in the government that acts as a mediator to FOIA requests. And then the FOIA Improvement Act of 2016 made a number of further procedural changes. It created online portals for requesting government documents like FOIA.gov, FOIA Online. Addition of a requirement that agencies post online responses in cases where there have been at least 3 instances of requesters, so you can have sort of a repository of documents there already. There's Chief FOIA Officer Council, and there's all the dispute resolution services offered by OGIS really are there for the taking, but they're put in letters. Agencies put out letters that have a paragraph that says you can go to OGIS if you want to dispute some aspect of an initial determination. It is not a secret that agencies are slow about responding to the FOIA, and it can be a very frustrating process. There are queues, and where there are simple requests, agencies do a good job of either meeting the 20 days that the FOIA statute has for time limits, or close to it. And then more complex requests can take a fair amount of time. I think agencies some are very cognizant of that and try to set deadlines for requesters that they're going to meet, but complex requests in a digital age with many thousands or even millions of documents to go through are not going to be, the request is not going to be responded to in 20 days. And that's for sure. And there is, let me just go here. So yes, the delays can be long. I mean, 17-year delay is obviously too long for a FOIA request. And one would hope that it is not the norm, and it isn't the norm. But whenever these things occur, the government gets dinged by either a public interest group or otherwise, or journalists. But there are successes, and there are successes here. This is a success by the National Security Archive, where they started in 2002 asking FOIA requests, and they got 4,700 records, but the process led to basically 47,000 pages years later being released. That's a good process. Here's a process where, as pointed out by Muckrock, a lawsuit filed, a FOIA, released 13 million pages that were involved with the CIA's program called CREST. And there are and one more that I'm putting out, Interior. There was a FOIA request by Politico for what Interior had been doing in terms of waivers of offshore drilling safety rules, and there a lot of information, a lot of records were given out. I could spend the next hour talking about hundreds of successes, so I don't want anyone to think that there's complete frustration with the process. Supreme Court has repeatedly talked about the FOIA as a way to pierce government secrecy, and that is great. In 2019, there were over 850,000 FOIA requests, and that number's been pretty stable for the last couple of years, but it's a tremendous industry for the part of all government agencies to deal with that level of requests. Now, I am of the belief that FOIA is successful in fostering transparency and accountability in government. President Obama had an executive order on day one emphasizing that point. Some have argued that FOIA's relevance is diminishing over time because of open data. A brilliant professor in New York, Beth Novak, has written a Yale article that basically said that if you have open government, if you have open data where government is putting up data online, then the FOIA is a slow process comparatively and not needed. I strongly disagree with that. And the reason is that in a digital world where we're having millions and millions of documents and even more, as I will allude to, I think the FOIA is relevant because by percentage, the fact remains that only a tiny percentage of government records will ever be on the web. Most are under the waterline, and particularly email. So there we are. Now, I promised that to my fellow CAFE faculty that I would do a sort of nuts and bolts part of this talk on mechanics. So this is for individual students that may not have encountered FOIA before, and we'll just go through the basics without doing it at length. As an aside, one could spend an entire day, an entire week learning about aspects of the FOIA, and various organizations have conferences like that, and there are extensive resources on the web. But here we go. So first of all, you don't need a reason to file a FOIA. Agencies can't ask you why, except in a rare case where you're asking for expedited processing. But any person, US, foreign, can file a FOIA. It's unlike litigation that I'm used to, where courts balance the needs of a plaintiff or a party against the burdens of responding to document requests. That's not the case. You can ask for a set of documents that are in the millions, with a caveat about search fees involved. So in response to a FOIA request, agencies are, by common law, by the law that's developed in the last 50 plus years, is that they need to do an adequate search, reasonably calculated to uncover relevant documents. Not a perfect search, but an adequate search. And agency records may consist of documents in all sorts of forms. So email, but all the other types of electronic media that exist. And one should specify, if you know that you're asking for photographs, that you're asking for photographs. But there could be in any form. And the process in a nutshell, and this is a very quick overview, you file a request, you get an acknowledgement from an agency. Don't expect the responses, as I said, to come in 20 days, but the acknowledgement should come in 20 days. In most cases, I know that I, as a requester, have gotten from many places that I file FOIA requests, that they at least are saying, hey, we're working on it. And then there's a determination about a fee waiver if you've requested it in the initial letter. More on that. An agency may ask for clarification before starting a search for documents in paper form or electronic form, and that's a good thing. And I will talk about that too. If any responsive documents are classified, well, there's supposed to be a very granular line-by-line review. And if, for example, you ask the FBI about documents where the CIA might have equities in them, that they're shared information or originating information in another agency, it's referred out, or agency consults with another agency, and that takes time and may take a lot of time. Eventually, there's a determination letter. The documents to you will be released in full or withheld in full, or there'll be a release partially and with redactions, and hopefully with annotations next to those redactions about which exemption was applied. And I'll get to exemptions in a moment. If you wish to appeal, you have a minimum of 90 days, that's in the statute. Your appeal will be dealt with usually by an attorney or a senior official. At the National Archives, I would be the second level person to draft an appeal response after I took a look at whether additional documents would be released. And then the deputy archivist would sign off on the letter that I draft. But that's the usual thing that, the first instance of FOIA offices does the initial determination in the letter. Secondarily, it comes from higher up in the agency. And you have the right to seek relief in a federal district court. And whether expediting processing is possible, well, yes, but there's a very strict test about it. Someone's life, physical safety, there's an urgency, there's a threat there, or there's an urgency in terms of a federal government activity. But I must say that, it's not many FOIA requests are expedited under a very strict test. How much does it cost to file a FOIA request? Well, nothing if you're a student or a professor and you say it's for an educational purpose, not a commercial purpose, and you meet a public interest test, which actually has a few elements to it, but it basically comes down to that your request will significantly be an aid to public understanding, contribute to that of the operations or activities of government. And it's similarly true with a newspaper organization or public interest group if you can meet similar tests. For everyone else, it's also nothing. It doesn't cost anything if you're asking for something that is under 100 pages. In most cases, agencies will waive the fees for that. However, if you're asking for a larger request and you don't meet a public interest test, if you're or educational test, then you're going to have to pay search fees. And in theory, copying costs, although I must say, this has been something that I've puzzled over, why there are any copying fees in an age where you have born digital records and you're getting them in electronic form. And so there's no Xerox machine involved, but in any event, and I've so far experienced no agency asking for copying fees. And I've met the public interest test in my FOIAs that I filed. There are 9 exemptions to the FOIA. I am not going to spend much time in this lecture going over these exemptions, except for one of them, exemption 5. But if you're asking for national security records, there's an automatic process that's triggered for a declassification review. There are B3, there's some personnel practices in B2. In B3, really, there are hundreds of statutes out there that exempt records from disclosure, and FOIA recognizes those, like, for example, your tax forms, IRS, or census data. There are specific statutes that prohibit disclosure of those records. And so B3 is kind of an umbrella catch-all for that. Confidential information in the form of trade secrets or commercial or financial information. Supreme Court has made it easier actually for corporations to assert that their documents are confidential when they've submitted them to the government, so that competitors filing FOIA requests can't get at them. We will pause on B5. I will come back to it. B6 is a provision that, despite the language here, it basically covers anything that's personal. So think about PII or personal information held in government records that would constitute a clearly unwarranted invasion of personal privacy. There's a balancing test that courts use. They weigh privacy interests versus the public interest in disclosure, and agencies should weigh that too. There's an exemption for law enforcement records in various categories. Obviously, if you're asking for records about an active investigation, they will be denied. B8 and B9 are very esoteric. And there are 3 exclusions on top of the 9 exemptions that have to do with particular aspects of law enforcement or national security involving informants, involving intelligence, where also those records are exempt. So the presumption is openness, except for records that are within these categories. Everything else is fair game to be searched by a government agency. And these records are also records that might have exemptions to them, might have withheld material, or also need to be at least accounted for when they are withheld. There are a couple of other conditions. One is a recent part of the FOIA Amendments 2016 that said, hey, an agency should be releasing information unless the agency reasonably foresees that disclosure would harm an interest protected by an exemption or disclosure is prohibited. The question is whether this is honored in the breach. Here, I have enormous frustrations as a FOIA requester as to whether agencies are actually doing a reasonable job of applying this reasonable foreseeable test. So that's something I could talk to people offline about. Additionally, agencies are to consider whether partial disclosure of a requested record is possible or not possible and take reasonable steps to segregate. That's the heart of my research, which we will get to. For everyone here, you should know that presidential records are exempt for 5 years after a president leaves office, and in certain categories of restricted records, up to 12 years after office. Interestingly, the exemption 5, including the deliberative process privilege that I will get to, is not available for presidential records. And that's actually key to how I got a test collection in the research. Okay. I can't help but also just make a point here that there are 50 state FOI laws that exist, and they have all sorts of interesting exemptions to when states are saying you can't get records from them. I mean, there's, again, a presumption of openness. But here, because I'm at an iSchool, I thought it would be of interest that there are exemptions in numerous states that account for records that are coming to archives in universities and museums and government depositories from donors who have basically restricted access to those records. And so the statute recognizes that and says that if that's the case for donor restrictions, the public at large is not going to also get any access to this. Now, I quickly got the slide here, but I couldn't help but when I was going through this and looking at exemption state law, there are all sorts of interesting exemptions. And one of them is in Louisiana about alligators. So the Department of Wildlife, in terms of alligator shipments or alligator skins or whatever, records about that are off limits. And there's all sorts of interesting categories of records in the 50 states that under state law that have numerous exemptions. Luckily for us, for FOIA, for the federal government, there are only 9 exceptions. Okay, we go here. The Office of Government Information Services is very important as an entity where if you're having any difficulty with a logjam, any difficulty with delays in getting records out of an agency, you can appeal essentially, or at least go to OGIS, write them a letter, send them an email, and the staff there will attempt to mediate and attempt to resolve the problem. This is kind of a secret in government, even though it's in letters and boilerplate. Very few individuals, I think, take advantage of the services of OGIS, and they should, since it is a mechanism to sort of rattle the chain of agencies to why aren't they doing a better job of responding. Okay, we are in a transformational era. This may have been what FOIA envisioned in terms of government records in 1966 or 74. It's not the world now. The world is this. This is the world of government records. They're on servers. And it will be the world of the National Archives too, where you can't walk in and get records easily off of one of these kind of servers. You can get them out of boxes if they're World War II records, but you can't do this. And this is the world of the future for iSchool students and for all of us that have been in government and are in government and dealing with access. The paradox here is that we all want a digital government, an e-government to function, to be able to provide citizen services. But there are issues, serious issues with access affecting historians, journalists, and everyone because of the tremendous growth in the volume of electronic records in the space. Now, NARA has recognized this, an OMB in a memo from archivist David Ferriero in 2019 set a mandate down. It set a sort of a gauntlet to all agencies. You're going to manage your records electronically, and any records that are deemed to be permanent in nature under a record schedule that are going to be transferred to the National Archives in the future, the transfer has to be digital or electronic. And so everything is going to be electronic at NARA. There's no paper anymore except legacy records from decades ago. This mandate has a very big effect. The 2022 mandate that after December 31, 2022, all records created after that date will be in digital or electronic form coming to NARA, permanent records, and managed throughout the government electronically. It means that there really are, we're in Carl Sagan territory here. It's billions and billions of electronic records subject to the FOIA. And this may not be a secret, but it is a looming public policy issue that I've been on a soapbox for, that NARA and every federal agency needs to sort of step up and understand what is coming. The wave is coming. Part of that wave is a policy that I had a hand in called Capstone, which was put into effect really in 2016, where government, instead of print to paper for emails, agencies have been embracing a management of emails, which means email archiving, where the senior officials at an agency, whoever's been designated, will have their emails be permanent, and everyone else's emails will be preserved for 7 years if they're substantive emails. And that means that there's tremendous accumulations of emails in large cabinet agencies and throughout the government that are subject to FOIA requests. And so when I'm saying you need to think about that for sort of best practice here, think about Capstone. I'll be talking about that in a second. Oh, here we go. They're also on a website that NARA maintains the list of agencies that have adopted the Capstone policy. And so you could look at that particular agency and see how many officials are having their records permanently saved at the agency for eventual transfer at NARA. And that's a guide to you for, asking in FOIA requests, who would you like to have the records of? Now, so there's a good news and a bad news aspect of this. The good news is that government is saving a tremendous amount of records, historically, a huge amount of records, especially in email, but across in terms of electronic records in any type of format or application. The bad news is that this volume is very difficult to search, and it's very difficult to filter for FOIA exemptions. And that's something that is a vexing issue. And it was recognized by this FOIA advisory committee that I happened to sit on a term ago, that really the archivist should take a lead in looking at advanced search methods using AI to look for, find responsive records for FOIA requests, and to identify sensitive material that are really within the FOIA exemptions that are legitimately withholdable. So that's an aspirational goal. And I know that the archivist takes these recommendations seriously. I'm not going to spend much time on the AI aspects of search. This is a well-known problem that lawyers for 15 years have been addressing through means known as predictive coding or technology-assisted review, where they've been using machine learning techniques to find responsive documents. The law firm I came from could go through 10 million documents in a weekend and find responsive documents. I wish the government would be able to do that. Some litigation parts of the government are having that software. I don't think the kind of software like that has been basically something that the FOIA offices or the records management people at agencies have been aware of or handling. And I certainly want to make the case in any forum that I'm in that this is the future. The future is finding, so apart from advanced search, which is really important, the future is also finding sensitive information in those records. And you can see that depending on the exemption, exemption 6 with personally identifiable information, there's all sorts of types of information that are covered by B6, including not just social security numbers or whatever, but personal health information or law enforcement information, criminal histories. This stuff is not as easy to find as certainly an expression of a social security number. So there are sensitivities in government collections that need help. Now, I'm going to now spend a little time on exemption 5. And because that's what the basis of the research that I've been talking about are. The exemption is one that is about interagency or intra-agency memoranda or letters. And what it really means is that in practice, it translates into shielding documents that are under attorney-client, attorney-work product, or within the scope of deliberative process. And as to the latter, deliberative process means an agency thinking about what it might do as a decision on any matter, whether it's drilling in Alaska or whatever any agency wants to think about. They're going to make a decision. They're going to have opinions, conclusions, recommendations in documents going up to decision makers. And the question is whether those can be withheld. There are two conditions for a document to be met for a document to be within exemption 5. One is that it's pre-decisional, decision hasn't been made yet, and one is that it's deliberative in the way that I was just talking about. And subject to certain exceptions, agencies have a duty to segregate factual matters, factual portions of documents that exist. So, and those factual portions should be released, and the stuff that is opinions that's about deliberations can be withheld. Justice Barrett had a recent opinion on FOIA that talked a little about this, a little process privilege, and quoting prior case law about advisory opinions, recommendations, deliberations, and it encourages candor, proves agency decision-making. So there is a good thing about withholding some information that's subject to a deliberative process. It's a legitimate reason for some withholding. However, it's widely thought by the public interest community that there's an overstamping of documents and withheld, basically an over-redaction of exemption 5 for all sorts of reasons, including that documents may be embarrassing. Now, I have a pretty esoteric example here, but I just wanted to show that in this, the organization POGO was looking for immigration and records of ICE, part of DHS, and two different public interest groups got two different answers from the government. One got a B5 exemption completely. The other, the agency released the same document. So that's sort of a mistake, inconsistency. But the fact is, part of this paragraph is just factual in nature. It's talking about mental health teams and their roles and what's happening on the ground. Part of the document is arguably recommendations. It talks about what could be done, what should be done, and so forth. And so this is a very hard document. It's actually harder. It's probably more difficult than the document set that in our research. But the fact is that the goal here would be to have an AI method that could easily parse, or at least parse facts from opinions in documents. That is a hard problem. So Doug Ord and Dr. Syed, who got a doctorate degree, is a PhD student when he was doing this, and myself, we did a little sandbox exercise. I took a look at Clinton White House records that have been put online 12 years after the Clinton presidency is over, but contain deliberative material. And it's a unique kind of collection, a test collection for research, because you don't really see this in federal agencies as much, that online where there's deliberative stuff that has been put up in any large quantity. So I used these presidential records as a proxy for the FOIA process. I looked at two individuals, Elena Kagan, Cynthia Rice. They're both on the Domestic Policy Council under President Clinton. Obviously, Elena Kagan went on to be a justice, Supreme Court, and looked at batches of their records. And here's what we did in this research. I did a coding exercise of paragraph by paragraph in documents from the Clinton Presidential Library. I looked at to see whether there's factual information or whether a paragraph contained deliberative material, recommendations, opinions, whatnot, that could be withheld. And then I invited a colleague of mine from the FOIA Advisory Council, Patricia Weth, who's a wonderful guru of FOIA, and she coded documents herself in a batch. And so I coded about 4 or 5 batches. She coded 1 batch. We compared results to get a consensus opinion on what is the deliberative material in a couple of, in hundreds of thousands of documents. And so these were various collections. You can see the number of paragraphs in the middle there from Elena Kagan or Cynthia Rice that I looked at, different topics. The A and B at the right on the second row is that both Patricia and I looked at that document set to train an algorithm with. And then, whoops, I don't see this. Okay, I'm missing a page here on this, but here's the bottom line that for the research, and which is that on the left, the rows are different types of classifiers, AI classifiers, linear regression, support vector machines, and the coding that we did in my coding was compared with batches of either Ms. Kagan or Ms. Rice's records, and then the second lawyer, Patricia, also compared, and then consensus coding compared. And we looked at different batches and we looked at different results, and the PRF, or precision recall, and a harmonic measure of the two. And I circle this because these are very good results. They are showing something on the order of 70 to 83% accuracy for the classifier to find portions of documents that can be segregated as B5 material. And I think that's a good thing. So is 70% enough? Well, what's your definition of success? I believe that it is a step forward because when you have that number, you could segregate into essentially 2 piles, documents that don't have that exemption to it, that is B5 deliberate process. You can put it over here on the left, and you can put on the right documents that are potentially subject to a deliberate process privilege, and then have human review take a look at its samples and take a look before documents go out. And it may well be that by doing that process, one can speed up the overall review, so you don't have 17 years or even 6 months. Okay, Roswell. Well, before I get to Roswell, there was a point that I skipped, and let me just look at the time here. Okay, so there was a slide that I meant to present, and which is sort of optimizing the FOIA process. And here's what I say on that, which is that one needs to be very specific in one's FOIA request in targeting the agency that you want to file a request with, and the individuals that you think might have responsive records, if you know them, and the time period for your request. The more specific and the more narrow the request, that's a good thing. And beyond that, what I really want to emphasize, I'm sorry I don't have the slide, I'll put it up, or it will be made available as part of this lecture, but online, what I have found as a part of the process is that once you file your request and you made it narrow, what you need to do is engage, to be proactive with the agency. Don't wait for them to do a determination. They might ask you to clarify the request, but go to them and ask them what are the search terms you're going to use against the email Capstone repository? And can I see a sample? Can I have an interim response of like 100 documents to see how you're doing, to see what redactions you're making, and then to have a conversation about that? And you can, I think, accomplish a great deal if you are taking your request to the agency and not be afraid of dealing with government. In my experience, everyone on the other side of the equation, everyone that I've met as a FOIA officer in government or attorneys working on it, do want to do the right thing. There may be enormous delays because of frustrations that individuals in the government have about dealing with other agencies or resource issues or whatever, but everyone wants to get to yes, that give as many documents as possible. And so why not engage? And so that's really the central lesson, the central takeaway I want to do before talking about UFOs. Okay, you've indulged me on that. Roswell. Well, okay. So the answer to where to find Roswell records is to think about what agencies might have such records. And the first could be the FBI. And in fact, there are records that are up on FBI's website that relate to Roswell. And in particular, there are interesting records that may indicate that it's high air balloons, but in terms of what was seen as a flying disc. But there is a vault that one can look at in the FBI collection. And does it expose all the secrets? Well, probably not, but there are articles out there that sort of criticize what has been put up and how closely it's been examined. The National Security Agency has a site that has the Roswell incident as a very long document on the site. And at the bottom there, you can see research located no records at existing Air Force offices that indicated any cover-up. That's different than perhaps than actual records about aliens. But anyway, so that site is one to go to. There it is. But my favorite site to go to is the National Archives, and which has a Project Blue Book, and it has a number of pages that devoted to UFOs, to Roswell, to Area 51. And one should think about the National Archives in any kind of incident. If it's 1947 that there's a potential incident, well, those records would normally be expected to have traveled, to have been transferred to the National Archives. And if they're unclassified, well, they are available. And so NARA has various websites reporting on Roswell. There is continuing interest to the present day. The Pentagon and Congress, a number of senators, prompting aside from a 60-minute story in the last year, prompting a further investigation conducted by various intelligence agencies. And you can read all about it in an Office of the Director of National Intelligence assessment about unidentified aerial phenomena. So the quest continues, and that report, the D&I report, has been noted. It has been noted that there are some anomalies characterized in the report, with unusual flight characteristics and whatever. And so there are some explanations, but some remain unexplained. And so, the truth is out there. If you want to believe, that's fine. I think the best place to look is in archives too, and I will leave it to all of you at that. There's a number of places to go online with tremendous amount of information about the FOIA. I'm particularly enamored of a number of public interest sites that go through the steps that you need to file FOIA requests, but also, and give tips about it, but also give a lot of information about lawsuits that have happened in the past, but also current litigation about FOIA. And it's really fascinating reading for those that want to dive in. There is a DOJ guide and a Justice Department guide that is hundreds and hundreds of pages long, describing case law on the FOIA. And so with that, I will take questions. I really thank everybody for hanging in, and let's see what we got.
Thanks so much, Jason. That was so interesting. I will say folks are welcome to put questions into the chat. You're also welcome to raise your virtual Zoom hand and I will call on you. And Jason, there are two questions now waiting in the chat for your attention. The first from Mary Helen Washington.
So let me just read this for a second because I was not reading it as I was going along. Trying to get the FOIA file. And no record of her. Well, okay, the question is, at what stage of your request is there? So if you know that there's a particular individual's, records related to her, then the question is, to what extent have you engaged with the FOIA public liaison and or attorneys involved, and where are you? If you've already received a determination and then appealed, well, then your only venue is to court. You might want to think, if you're at an earlier stage, this might be something to address with OGIS if there's some chance that that there are records that are there. So next, and I'm happy, there's a tradition here at the cafe that people can actually pipe up and where they're no longer muted and have a conversation with us. But let me just go on to the next in the chat. Doug Ord writes that you've told us that the government could use AI to do better. Is there potential for using AI to help the requester to formulate good requests? And so absolutely, if there are, I could see where if there were large scale document releases and individuals could take advantage of software tools to look at those releases and then refine a request again, to file a second request, that would be terrific. I mean, in litigation, lawyers are used to each party getting a lot of records to go through, and they should each be using advanced search tools to do that if they're corporations or they're a certain size. So in theory, one could do that. I think that's off in the future because I don't think these AI methods are generally available. And frankly, agencies are not going to be releasing huge amounts of records that would satisfy my condition. Other than that, we can have a conversation about it. Oh, more. Okay. How do you think the FOIA metadata tag will improve access and backup queues? I think metadata is good. We learned that at the iSchool. And to the extent that documents have fields which are populated in certain ways, it makes the searches much more efficient. And people should be relying on it. And whether that metadata is publicly accessible is an open question, and it's also not clear to me whether sufficient metadata can be generated on a document by document level so that it's there to then be searched against. But it's aspirational. Okay, if the agency says we'll suffer harm in the future, how can we argue against that statement? Well, there's a developing body of case law that is pushing back on agencies about foreseeable harm. Unfortunately, that case law means you have to get to court. And so I think what I have been doing is citing the recent DC Circuit decision in Reporters Committee versus FBI, which was out this past summer, the DC Circuit decision of 2021, that really restricts the idea of foreseeable harm in at least a category of records that the FBI had. And so if you cite decisions that are favorable to you at at any point in the FOIA process, even in your initial letter, hey, you know, that I expect that you will apply this test, then I think that may be a way to have a conversation. I can tell you, I'm so glad this question was asked, because I can tell you that I am having that precise conversation with an agency right now on one of my FOIA requests, where I'm engaging. I have said to the agency, I will reduce my request from the number of hits from 20,000 down to 2,000 on whatever I'm requesting, if you are willing to talk to me about the redactions that you did on a sample, and that I have a conversation about foreseeable harm with you. So again, that is what I'm emphasizing here. That really is new. I don't see this much on the public interest sites. It's just actively engage with the agency. Don't be afraid. Okay, next. If the emails are voluminous, 3,000 pages or more, what is the diligence required for processing? It's still good practice to read line by line. The common law of FOIA is that, yes, a line by line review is required and expected, at least. But in reality, at the initial stage of a document request, the problem is that there's too much time spent on that, and there's enough time going by on releasing documents. So it makes a lot of sense for agencies to release documents in full or withhold them in full, and then have release in part if they can, but have a conversation about why the documents were withheld in full, and hopefully do a better job of which portions could be released, and then also with the part that, you know, the segregation thing, do a better job. So when you're up at 3,000, it takes time, and you're up at 30,000, it takes even more time. And so it's incumbent on requesters to try to narrow their request. If you're looking at an email repository of 20 million emails at the State Department, you ask a broad request about, you know, everything about Ukraine in the last administration or whatever, you're going to get a lot of hits and a lot of documents. If you're a public interest group or you're a professor like myself and you meet the test, the agency is going to have to search all of that and review all of that. But, you know, it may be months and years before you get the amount of documents that have been hit. So it's incumbent on everybody to try to narrow requests.
So Jason, before you answer the next question in chat, I'll note we have one hand raised. And I also wanted to say, Mary Helen Washington asked the first question in chat. I also saw you, Mary Helen, unmute yourself briefly. If you wanted to pose a follow-up question to your earlier question, just go ahead and raise your Zoom hand and we'll come back to you. And Victoria, did you want to go ahead and ask your question out loud?
Yeah, thanks, Jason, for this. My question was about the machine learning or AI training data that you developed, and whether your sense of the materials that did not, well, I also just want to make sure I understand. So you said the 70 to 83% were classified as meeting the, sorry?
You're classified correctly.
And so for the things that didn't get classified correctly, were you detecting emerging patterns as to why, or was it still fairly unclear an area of active research?
That would have to be, yeah, further research. I guess there are difficulties with text, just generally well known, and there is a certain fuzziness to, you know, what constitutes recommendations, opinions, deliberations. And so one would expect that you're not going to get perfect matches when you're trying to compare the patterns of one document against another document. Beyond that, we can have a discussion offline.
Okay, Jason, I'll redirect your attention back to the chat where Andy Adams has posed a question.
Sure. Since COVID, video conferencing has become a new standard for holding meetings. Do you anticipate that AI will be able to search through recorded conferences? Okay, well, I'm going to have to defer to my very expert colleagues here for the iSchool who can pipe up. I mean, my experience as a lawyer has been searching against texts and searching voicemail that is then transcribed to text. If there's a transcription of a video conference, that is useful, helpful. There may well be that there's an audio feed that can be recognized as something that can be played with. But when you basically have to reduce what I believe, but I'm a lawyer talking, not an AI subject matter expert. What I believe is that you have to be able to use these kind of AI methods that we were using. You need to be able to reduce the data set to basically tokenizing it, that you have terms of some kind that make patterns in the documents, that so that you can say this one is like this one, this that you have a training set and then you find other documents or find whatever like that. But I will defer to my colleagues here to pipe up.
Any colleagues who wish to pipe up, aside from me, and any questions, please feel free to raise your hand or pop them in the chat.
Oh, we should talk, Jason. For example, one of the things that can be done is to figure out where the decision points in meetings are by looking at the pattern of back and forth that goes on. And there are some systematic things we could exploit, and that might help us to better focus. So I think it's a great question.
Well, maybe it's our next research project, Doug. Yes.
I was just piping up to say that there are some emerging on-the-fly transcription of video and audio that are getting better. And so in a sense, that step of transforming these media into text in order to do the same process that Jason was presenting about.
Absolutely. Absolutely.
We can also build cat detectors in the video.
The best kind of research.
Yes.
Sangeeta, by the way, asked a question that we skipped over.
Oh, okay. If the emails are, no, I got that one. What else?
I'm sorry, I missed.
Yeah. Anyone else have anything here?
Any last questions as we approach the hour? If not, we'll give Jason a big round of applause. Thanks so much for elucidating this for us, Jason. This has been fascinating. And thanks everyone for joining us. Our next event is in 1.5 hours. Please see the Cafe events page for more information. And we have more coming up not next week, the week after. See you soon. Thanks so much, everybody.
Thanks, everybody.